Welcome, everyone. We have some more people joining us. So we're just going to give this one more minute as you get settled in the virtual room, and we'll get started very soon. Thank you. Okay, good morning. My name is Ben Bingle. I'm the director of the DeKalb County Nonprofit Partnership at the DeKalb County Community Foundation. I want to thank you all for joining us today for this webinar on the Paid Leave for All Act. We have a few housekeeping items before we get going. First, we are recording today's webinar, and that recording will be shared with you along with the slides. We'll share those by email afterwards. We do have everyone muted, so you should feel free to use the Q&A and the chat features built into Teams, and we're going to save some time at the end to address any questions that you submit. So with that, it's my pleasure to introduce our presenters, and a special thank you goes to the Illinois Department of Labor for partnering with us on this training. They've offered a number of these webinars on this topic for a couple of months now, and they graciously agreed to provide this session for DCMP. So we appreciate that collaboration and their partnership. Leading us through today's webinar are Jason Keller, who is Assistant Director of the Illinois Department of Labor, and Lydia Kalunga Merchant, the Leave Rights Division Manager at the Illinois Department of Labor. Welcome, Jason and Lydia.
Thanks, you very much. Would you like us to take it away, Ben?
Please do.
Okay, very good. As Ben said, my name is Jason Keller. I'm the Assistant Director here at the Department of Labor. I want to say thank you to everyone, Ben for hosting us, and then also for those showing up to the webinar today. We always stress this at the department that we preach compliance over being punitive, and so part of that first step is coming to a training like this to learn about the details of the law and understanding how to come into compliance. With that, I'm going to go over a little bit about our department. We are charged with enforcing laws protecting workers' rights on the job. We enforce over 25 different workplace protection and safety standard laws. We have offices in Chicago, Springfield, and Marion. We have 3 labor law enforcement divisions: the Fair Labor Standards Division, Conciliation and Mediation Division, and OSHA. We also have an amusement ride and attraction safety division that keeps patrons safe at county fairs, at trampoline parks, and other amusement attractions. And then we've also just created the new Leave Rights Division that was established this year, of which Lydia, who you'll see on the webinar here, is leading that division and helping stand up our new paid leave law. The Paid Leave for Workers, for All Workers Act, the background of that is that the General Assembly basically is stating that it's public policy interest of the state for all working Illinoisans to have some paid leave from work to maintain their health and well-being, to care for their families, or to use for any other reason. And we do bold that specifically because under the act, employees can take leave for any reason of their choosing. Illinois is one of only 3 states with paid leave for any reason. And we're going to quote the act just for clarity. The provisions of this act shall be liberally construed in favor of providing workers with the greatest amount of paid time off from work and employment security. So the format of today's presentation, we've done several of these. We're getting a little bit better polished with it, but we do want to just kind of go over some of the ground rules. We've modified the presentation to provide information about various sections of the act and to address frequently asked questions that we have received during past presentations and via email from employers and employees new to understanding the law, as well as of more advanced practitioners who have targeted specific questions regarding particular sections of the law. Questions will be allowed at the conclusion of the presentation. We do encourage you to please visit our website and the frequently asked questions that can be found there. We will show you where that is on our website. And then we do have a recording of basically the same presentation that we're going to give up on the website. And as Ben alluded to, we will get a PDF of the presentation to you as well. This presentation is intended to offer general guidance on the Act. We don't give legal advice. We will tell you how we're going to enforce it. However, we will not give you legal advice on the Act. Employers should consult their own legal counsel to determine what actions they should and should not take in order to comply with the Act, including any situations specific to their business or operations. So we will cover, as far as an agenda is concerned, who is covered under the law, providing loading of time or accrual of paid leave time, how an employee can use paid leave, other employer responsibilities under the Act, penalties and enforcement if you are found to be in violation of the Act. FAQs again on our website. We will point that out at the end, and then we will run through some of our most common questions that we receive. And at the end, again, we will have a question and answer session. The main takeaways that we want you to come away with from this presentation: any employer who has a bona fide qualifying pre-existing policy that allows all employees to take 40 hours of paid leave for any reason of the employee's choosing is not required to modify the terms of their policy. I think we'll probably get questions on that, but if you have an existing policy that an employee can take at least 5 days of leave for any reason, then there's no need for you to change your policy. The second one is one that I will stress and I'll hit upon again in the presentation. It's critical for employers to develop a policy by which they're going to operate in concerning this law. Employers may enact a reasonable, clearly communicated policy that establish circumstances in which the employer may deny an employee's request to use paid leave due to operational necessity. Employees should know where they stand and be able to plan ahead. And any enforcement action that we're going to undertake, this is one of the things that we're going to ask for from an employer. If there is no policy in place, that will put you in a much weaker spot as an employer. So highly, highly recommend coming up with a policy. IDOL will be emphasizing employer compliance assistance from or for the first part of 2024. However, the department will still review every complaint to determine whether it warrants an investigation. Again, a recording of this webinar is on our paid leave website. I am going to turn it over to Lydia, but not before I say what a wonderful job she's done. She's been a welcome addition to our department here in the beginning of the year and has really helped the department stand this law up and get it going. So with that, I want to turn it over to Lydia. Take it away.
All right. Thanks, Jason. Thanks so much. So again, my name is Lydia Colunga Merchant. I'm the Leave Rights Division Manager here at the Department of Labor. So I'll be covering fairly like who is covered by the Paid Leave for All Workers Act. So I know Jason kind of spoke a little bit about this with the bona fide pre-existing qualified position. So what if an employer has an existing policy such as paid time off, paid sick leave, paid vacation policies, a mix of all of those? Do you have to modify or change that program? And so again, like we said, if the bona fide qualifying pre-existing policy meets the minimum amount of paid leave set forth in Section 15A of the Act, which is those 40 hours of paid leave per year, and your employees can in fact take that amount of paid leave for any reason each year, then you won't need to modify the terms of your pre-existing policy. And so we do want to emphasize, your employees having that ability to take that leave for any reason of their own choosing and being able to take that leave each year. Again, nothing in the Act is construed, well, this is quoted language from the Paid Leave for All Workers Act, Section 5C. Nothing in the Act shall be construed to discourage employers from adopting or retaining paid sick leave, paid vacation, paid holidays, or any other paid time off or paid leave policy more generous than policies that comply with the requirements of this Act. So I know some questions we've received in the past have been, if I offer 2 weeks vacation, is that enough? So again, if you have a policy that's more generous, as long as you're meeting those minimum requirements of the Act, then likely there's no need for you to modify that policy. And so one pro tip that we do recommend is that if you believe that your current paid leave policy complies with these provisions, then, we really suggest that you communicate these policies clearly to your employees, how they are in compliance with the new Act, and that you maintain supporting documentation, including any of the record keeping requirements that track the amount of paid leave accrued, paid leave used, and any remaining paid leave balance. So over the state law and the overlap with local ordinances. So it's our position that the law applies to any employer who doesn't already have a qualifying pre-existing policy and who isn't already covered by a local paid leave or paid sick leave ordinance in effect on January 1st of 2024 that meets the minimum standards of the Paid Leave for All Workers Act. So currently we know that the city of Chicago and Cook County have their own either paid leave ordinances or paid sick leave ordinances. And so it's our belief that for those Chicago employers and employees, and same in Cook County, that those ordinances would control and an employer should follow those. And so again, if you have any questions about a Chicago ordinance, please direct those to the City of Chicago's Office of Labor Standards. And same for Cook County, their paid leave ordinance, or questions about their paid leave ordinance should be directed to the Cook County Commission on Human Rights. So under the Paid Leave for All Workers Act, the definition of employee has the same meaning as the definition of employee in sections 1 and 2 of the Wage Payment and Collection Act. Plus, there are a few additional categories. And so one question we get frequently is whether this act applies to part-time workers, temporary workers, seasonal workers. And the answer is yes, they do meet that definition of employee. Same for all domestic workers, meaning nannies, housekeepers, home health care aides, etc. Employees of state and local governments and agencies are also included. We've gotten a lot of questions about interns, and so we think that's a more fact-specific inquiry. But if you look at all the facts and those interns meet that definition of employee, then they would be considered employees under the Act. So again, if you have a question about who may or may not be covered, we would recommend consulting with legal counsel. And who is not covered. And so again, according to the Wage Payment and Collection Act, employee includes any worker who performs work for an employer unless that worker is a bona fide independent contractor. And so there is a 3-factor test to determine if someone is an independent contractor or an employee. So that first factor is, that worker being free from control and direction over the performance of their work, and performing work which is either outside the usual course of business or is performed outside all of the places of business of the employer, unless the employer is in the business of contracting with third parties for the placement of employees, and is in an independently established trade, occupation, profession, or business. And so everything we've bolded is our own emphasis because those are kind of the main keywords in this test. And so if a worker meets all three of these factors, then it is likely that they are an independent contractor and would not be subject to the Paid Leave for All Workers Act, except for those who are considered domestic workers. So even domestic workers can also be covered under the law, even if they are an independent contractor. Another question we get a lot about is what about union employees? So employers and employees covered by a CBA that is in effect on January 1st of this year are grandfathered in for the duration of that pre-existing agreement. And so again, union construction and freight employees are not covered at all by the Act, and we'll explain that in our next slide. But after January 1st of 2024, when unions and their employers are negotiating a new agreement, the parties may waive the Paid Leave for All Workers Act in new contracts or contract renewals, but only if that waiver provision is explicit, clear, and unambiguous. So as an example, there's a CBA effective July 1st, 2020 that expires on June 30th of this year. The parties will need to address that possible waiver when they negotiate a new CBA on or before July 1st, 2024. If there is no waiver agreed to and added to the contract, then the employer must comply with the Paid Leave for All Workers Act. Even, although the parties may want to bargain over individual provisions of the employer's policy. So best practice pro tip, from January 1st, 2024 moving forward, please consider inserting any language in a CBA regarding the Paid Leave for All Workers Act, whether the parties are deciding to waive those provisions or not. And again, different provisions apply for state agency employers and employees, so consult your HR or your union for more information. Also, there are some explicit exemptions to the Paid Leave for All Workers Act. And so these are some of those exemptions. So certain railroad and airline employees, certain higher education employees, so college and university students who are employed part-time by their schools, or some short-term temporary employees of institutions of higher education. Collective bargaining covered construction workers, collective bargaining covered package, transportation, and delivery, which is domestic and international freight. So these are written specifically in the Paid Leave for All Workers Act. And so if an explicit exemption is not listed, then that employer or employee is most likely covered. Now moving on to the definition of employer, under Section 10 of the Paid Leave for All Workers Act, an employer, the definition of employer has the same application and meaning as provided in Sections 1 and 2 of the Wage Payment and Collection Act, just like the definition of employee. And so employer is very broad and shall include any individual, partnership, association, LLC, business trust, temp agencies, any other person or group of persons acting directly or indirectly in the interests of an employer in relation to an employee for which one or more persons is gainfully employed. I know we get a lot of questions about small businesses. What if I have 5 employees? Again, under the Wage Payment and Collection Act, 1 employee is sufficient to be constituted as an employer. So the same goes with the Paid Leave for All Workers Act. And then again, employer also means the state and units of local government, any political subdivision of the state or units of local government, or any state or local government agency. Please note, employer does not include school districts organized under the school code or park districts organized under the park district code. And now I'll turn it back to Jason for some FAQs.
Thank you very much, Lydia. So one of the, I'll call it more controversial questions that we have received is whether or not municipalities or counties can opt out of the Paid Leave for All Workers Act in order to provide fewer hours of paid leave than what is required under the statute. The answer to that and how we are interpreting the law as written is that the answer is no. The department recognizes that under Section 15P that there is an exemption for municipalities or counties with a local ordinance in effect prior to the effective date of the act, if that ordinance requires employers to provide any form of paid leave, including sick leave. However, Section 5A of the Act sets the statewide minimum standard for the amount of paid leave that employers, including municipalities or county employers, are required to provide for their employees. Any local ordinance that is enacted or amended after the effective date of the Act must comply with all requirements under the Act. Given the potential legal implications of such local laws, ordinance, or regulations, it is recommended that employers consult with legal counsel prior to changing or enacting such policies, laws, rules, or regulations. Other questions that we have received are, does this apply to remote employees? And does this apply to employees who live in Illinois but commute to Indiana for work every day, or vice versa? IDOL has traditionally found Illinois workplace protections apply to employees who primarily perform work in Illinois for an employer that does business in Illinois. We would point you to our proposed rules for factors. Those are not yet finalized yet, but we do have guidance in our rules, and I'll show you where to find those later on. Other questions that we receive, is there an exemption for small business, and is there an exemption for not-for-profits? And the answer to those is no. The Paid Leave for All Workers Act lists several explicit exemptions, but there is no exemption for small businesses or not-for-profits or any other type of employer not explicitly exempted. Back to Lydia.
All right, thanks, Jason. So I'll go into, providing and using paid leave. And so we know that the Act recognizes two different ways employers can provide paid leave under the Act. And so that's through the accrual method or the front-loading method. So we'll start with the accrual method. So accrual means employees earn 1 hour of paid leave for every 40 hours worked. And so employees then accrue up to 40 hours of paid leave per year. And so a part-time worker, temporary worker, or a seasonal worker is entitled to earn paid leave under the Act, but because they work less hours per year, they may not accrue that full 40 hours of leave in that 12-month period. So for example, employee A works 10 hours a week. They earn 1 hour of paid leave every 4 weeks. And so if they work 50 weeks per year, then they're earning approximately 12 hours of paid leave per year. And then, also employee B works 20 hours a week. So again, they're earning 2 hours of paid leave every 4 weeks. And if they also work 50 weeks per year, then they're earning approximately 24 hours of paid leave per year. And all of this would be considered in compliance with the Paid Leave for All Workers Act. Now, the front-loading method for providing paid leave. So instead of requiring employees to accrue leave gradually throughout the year, employers may provide those 40 hours of paid leave or a prorated amount available to the employee at the beginning of that 12-month period. So that's what we call front-loading. And so the 12-month period doesn't have to be January through December, and it's something that can be determined by the employer. So for example, it can be an employee's anniversary date, like the start of their employment. It could be the fiscal calendar year, any other 12-month period. However, if the employer changes the 12-month period, then they must provide a detailed written notice to their employees. So that way, again, the emphasis is on employees knowing what the policies are and where they stand in terms of their paid leave. Also important to note that, if an employer provides front-loaded benefits, they may not be retroactively diminished. So here are some frequently asked questions we get about, providing paid leave to workers. So can we front load less than 40 hours to part-time workers? Can we prorate front-loaded leave for employees who are hired mid-year? Can we match our paid leave 12-month period to the fiscal year? Can we use an employee's hire anniversary date to set the 12-month period? And the answer is yes to all four. So again, an employer may design the front-loaded leave to be prorated according to their business practice, as long as the amount of leave provided is 1 hour of paid leave for every 40 hours worked. And again, employers may front-load this paid leave for part-time employees at that prorated amount, consistent with an employee's anticipated work schedule. However, an employer must add paid leave time if that employee ends up working more hours than expected. So that's an important item to note. Also, if an employer sets a January through December 12-month period and then hires an employee who starts in July, the employer can front load 6 months worth of paid leave until the start of the next period, at which point that employee would receive all of their paid leave time. And then if an employer wants to follow a July through June fiscal calendar year, the employer can count January 1st through June 30th of this year as half of a year, provide leave on a prorated basis for those 6 months, and then start a new 12-month period on July 1st of this year. And another question is, can we front load 40 hours for full-time employees and accrue for part-time employees? And the answer is yes. You can have separate policies that provide paid leave via front loading for some and via accrual for others. However, those policies must be applied consistently, communicated to employees ahead of time, outlined clearly in your written paid leave policy, and not be illegally discriminatory. And can an employer who front loads hours recoup paid leave if can an employer who front loads hours recoup paid leave an employee has used if the employee's employment ends before the end of the year? And so the answer there is no. So the law doesn't allow an employer to make an employee repay paid leave time that was front-loaded at the start of that 12-month period. So again, benefits that have already been provided may not be retroactively diminished. And so this also applies if you front-load that paid leave according to an anticipated work schedule. So if an employee ends up working less than expected, you cannot take back any of that paid leave time or make them repay their used or unused paid leave time. And provisions for overtime exempt employees. And so this would be, for example, managers, professionals, some salaried staff who would be considered exempt under the Fair Labor Standards Act. So how does earning paid leave work for them, especially if they're working more than 40 hours a week? So generally, for those administrative, executive, and professional employees who are overtime exempt under the Fair Labor Standards Act, the earning rate would cap at 40 hours per week, regardless of the number of hours those salaried or exempt employees work. So generally, employees that meet that exemption will accrue 1 hour of paid leave per week, even if they were to work more hours. So for example, a manager at a retail location, if that FLSA exempt manager who works more than 40 hours per week, that manager may be deemed to work 40 hours for paid leave accrual purposes. So pro tip, just, carefully with your counsel, review those Fair Labor Standards Act definitions to make sure that employees that you're classifying as exempt for paid leave accrual purposes are, truly exempt. And now I'll pass it over to Jason.
Thank you very much. So when can employees use paid leave? We want to make two distinctions here. Paid leave shall begin to accrue for your employees or must be front-loaded on January 1st, 2024 or upon start of employment for employees hired after that date. So that's for accrual. employees shall be entitled to use paid leave 90 days after January 1st, 2024, which we haven't reached that yet. It should fall right around March 31st, or 90 days after starting employment for employers, excuse me, I can't say that word, employees hired after that date. The 90-day waiting period only applies once for any given employee for the duration of their employment, either January 1st, 2024 for current employees or upon hire for future employees. So again, accrual starts right away when they're hired, and then 90 days for waiting period for using that paid leave for employees. The rate of pay for paid leave when employees choose to use it is discussed in section 15F. Employees shall be paid their hourly rate of pay for time taken on paid leave. Essentially, it's their normal rate of pay when they're would be normally working. Tipped employees and workers earning commission shall be paid at least the full minimum wage in the jurisdiction where they work. So, employers must allow for oral or written requests to use earned paid leave when employees request it. Section 15H of the Act states that employers can have a reasonable paid leave notification policy if the leave is foreseeable. Employers may require 7 days notice. If it's not foreseeable or unforeseeable, notice as soon as practical. And so that we realize that that is a little bit of a gray area. So we would best guidance to give you is that sorry. It requires employers to carefully consider operational needs and determine reasonable and foreseeability in light of the right of employees to take time off for any reason. Again, it goes back to having a policy in place. And again, I'll stress it's important for employers to have that policy in place. An employee may choose whether to use paid leave provided under this act prior to using any other paid leave provided by the employer or state law. That's in section 15E of the act. So just to make clear, it is up to the employee what type of leave they wish to use. Can an employer deny paid leave? If the employer enacts a reasonable, clearly communicated policy that establishes circumstances in which the employer may deny an employee's request to use that paid leave due to operational necessity. It must be in your employer written employee handbook and distributed to all employees. Again, we have further guidance in our rules, which are not quite finalized yet, but will be finalized hopefully in the month of March, and we will show you where those are on our website. Does paid leave carry over? Generally, under the Act, an employee's unused paid leave that was provided via accrual shall carry over annually. And as per section 15C, front-loaded leave that an employer provides does not have to carry over. The employee is only entitled to use 40 hours each year unless the employer chooses to allow them to use more. So it is possible for an employee to have more than 40 hours accrued on your book, but they are only entitled to use 40 hours each year. To get back to Lydia.
Awesome. Thanks, Jason. So I'll, answer some of these frequently asked questions that we've seen. So for example, can we deny an employee's request to use paid leave under the Act? Can employers set times of the year, such as holidays or peak periods when the use of paid leave is limited? And for firefighters and emergency responders, can we restrict the use of paid leave? And so again, nothing in the Act prohibits an employer from adopting a policy that establishes some parameters for taking leave and the limited reasons the employer may deny leave for operational necessity, such as to conform with legally required minimum staffing levels. Any such policy must be reasonable, must be communicated in writing to employees, applied equally to all employees, and conform with other applicable state and federal laws. And so, as Jason said, our proposed rules, which we're hoping will be finalized soon, provide additional guidance on what factors employers may consider when, coming up with these policies to deny leave. Another question we always get is, what about no call, no shows? And so again, an employer can adopt a reasonable policy regarding how they will handle no call, no show absences when an employee provides no notice. But employers cannot require the employee to disclose the cause for the absence, and the policy must be disclosed in the employee manual. So again, as we kind of have stated before, it's very helpful to have these policies written out, provided to employees, so everyone has an understanding of, what the rules are in terms of, requesting their leave. Some other frequently asked questions: can employers force employees to use paid leave if their employees request unpaid leave or another form of paid leave? And can I require employees to take sick time or any other time before taking paid leave time, or vice versa? And so the law says that an employee may choose whether to use paid leave provided under the Act prior to using any other leave provided by the employer or state law. So if you as an employer have another paid or unpaid leave policy or practice, then the employer can choose whether to use their paid leave for all workers leave time before using any other leave provided, or vice versa. So again, it's the employee that gets to decide, not the employer. And another question we get is, how does this interact with FMLA? So FMLA is the Family Medical Leave Act, and employees going on FMLA may use their Paid Leave for All Workers Act time concurrently with that FMLA leave. However, we at the Illinois Department of Labor don't administer or enforce FMLA. That's a federal law. So if you have any questions about FMLA, please direct them to the U.S. Department of Labor. Some more questions: because employees may carry over 40 hours per year and use can be limited to 40 hours, can employees bank their leave and carry it over forever? So again, we're hoping to finalize these proposed rules, but the Act doesn't specifically address this topic. The Act only states that employers can limit an employee's use of paid leave time to 40 hours per year. And even part-time employees who may not accrue a full 40 hours each year are entitled to use up to 40 hours each year if they have some of that time carried over. And can I make my employees take their leave half a day or a day at a time? So unless you as an employer have that bona fide qualifying pre-existing policy, the highest minimum you can set for your employees using leave is 2 hours at a time. So for example, if an employee wants to take 45 minutes of paid leave to run an errand, an employer may have a policy requiring them to use 2 hours of time. However, if there's an employee who wants to take 3 hours of paid leave, an employer may not require them to use 4 or 8 hours instead. So again, employers can always be more flexible or generous than the law requires. So if you want to let them take, by half-hour increments, by 1 hour increments, you're more than welcome. It's just that requiring someone to take a whole day when they may only need 2 hours, that's what the law, what the Act doesn't require. Payout upon resignation and termination. We have seen these questions a lot. So the Act itself does not require payout of unused accrued leave, or even front-loaded leave, unless that leave is credited to an employee's general PTO bank or an employee vacation account. However, employers should also consider vacation payout obligations under the Illinois Wage Payment and Collection Act. So another pro tip is just to review your policies very carefully and consult with legal counsel when you're thinking about whether, let's say you have that vacation plan that is already in compliance with the Act and there are no changes. just to consider those vacation payout obligations under the Wage Payment and Collection Act. And I'll also talk about some other employer responsibilities under the Act. So again, we have these pre-existing PTO vacation plans. So as we've stated before, if you have that bona fide qualifying pre-existing policy that allows your employees to take 40 hours of paid leave for any reason per year, then you're not required to add to or change your plan. And again, quoting the Act directly, nothing in the Act shall be construed to discourage employers from adopting or retaining paid sick leave, paid vacation, paid holidays, or any other paid time off or paid leave policy more generous than policies that comply with the requirements of the Act. An employer's existing vacation plan may already meet their obligations under the Act, so you, again, may not have to modify anything. As I've mentioned previously, there are some record-keeping requirements under the Act, and so you can find those in Section 20. And so employers are required to keep records of each employee's hours worked, amount of paid leave time accrued or provided if it's front-loaded leave, and the hours of paid leave used and when, as well as any remaining paid leave balance. And so this doesn't have to be on an employee's pay stubs, but be sure to have it on hand in case an employee asks for their leave time balance. This record retention requirement is for 3 years, so that's how long employers have to keep these records. You would also have to provide the department access to the records upon an investigation. So if we were to receive a complaint, we may ask to see those records. There's also public notice or a Know Your Rights poster required. This can be found on our website in English, Spanish, and Polish. If you require another language, please reach out to the department and we'll get that for you. But this must be posted in a place where employees frequently visit, so where you would have other Department of Labor or required posters hanging, this would be, another poster to include. Employers of domestic workers have special provisions, so just be sure to take a look at the Act and consult counsel if you do employ those domestic workers. Employee handbook. So employers are advised to develop an employee handbook or a personnel policy that clearly communicates any policies you want employees to abide by. And again, any such policies must comply with the Paid Leave for All Workers Act and any other applicable laws. And so the handbook must be in writing and distributed to all employees on or before the employee's first day. And in the absence of a written handbook, the department will still conduct an investigation of whether an employer unlawfully denied an employee their rights under the Act. So again, we take a look at everything, but these are just some of the records and documents we may request if there is a complaint received in our office. Retaliation is prohibited under the Act, so employers shall not consider an employee's use of paid leave as a negative factor in any employment action that involves evaluations, promotion, discipline, or counting paid leave under a no-fault attendance policy. So, for example, if an employer has a points-based attendance system that leads to discipline for absences, any instance when an employee is utilizing paid leave provided under the Act may not be counted against that employee. Penalties and enforcement. So complaints can be filed up to 3 years after the alleged violation. So any violation against an affected employee or employees, then the employee would be entitled to back wages, compensatory damages, a penalty of between $500 and $1,000, and other relief as appropriate. For any violation of the Act except a public notice violation, the department would receive $2,500 as penalty. And for a failure to post the public notice, the department would receive upon a first offense $500, and every subsequent offense would be $1,000. And I'll turn it over to Jason to close us out.
Thank you very much, Lydia. As mentioned in some other portions, actually Lydia, it looks like you might be sharing the,
Oh, sorry.
that's okay. Nope, thank you. Just wanted to go over where you might find some of the FAQs, our rules, and so on. Our FAQs were updated. The last date was December 27, 2023, so they are still fairly current. The department has proposed rules to clarify the provisions of the act. Again, on our website, they should be finalized sometime in the first couple of weeks of March. We recommend that employers and employees review our website for FAQs. We will update them as we get new questions in and we do more training sessions. And then, as I think Lydia alluded to, we do have our required posters up on our website, and I will show you where to get those. But the link for FAQs, you can see at the bottom of this page. I won't read that out loud because it's long, but we'll show you how to get there. So if you go to our website, which is at the top, labor.illinois.gov, we have a large gray box underneath the three pictures that says Paid Leave for All Workers Act. And if you click on that blue button, Paid Leave Information, it'll take you here to our main paid leave page. You'll notice that we have a quick summary of everything, including the email address that you can send questions to. If you come across them and want to send a thought to us, please utilize the dol.paidleave@illinois.gov email address. You will see a link to the full statute, 820 ILCS 192. You will find our proposed rules, and that's the link that says 47 IL Reg 15559. And then you will see our frequently asked questions there at the bottom link. If you notice below that, you'll see a webinar schedule. So I'll say if you're a glutton for punishment and want to go through this training session again, you can come back and listen to us some more. We have posted updated dates there, and you can register for the webinar there. So the main takeaways that we wish for you to have are that any employer who has a bona fide qualifying pre-existing policy that allows all employees to take 40 hours of paid leave for any reason of the employee's choosing is not required to modify the terms of their policy. Employers who are subject to the Paid Leave for All Workers Act may enact reasonable, clearly communicated policies that establish circumstances in which the employer may deny an employee's request to, I think it disappeared on me, to use paid leave due to operational necessity. And those are clearly bolded words, due to operational necessity. Employees should know where they stand and be able to plan ahead. The department will be emphasizing employer compliance assistance for the first part of 2024. However, the department will still review every complaint to determine whether it warrants an investigation. I want to just stop on that again and say thank you for attending today. As a government agency, you should expect clarity from us, and that's what we're trying to provide you, is how we see this act and how we're going to enforce it. That way you can plan ahead for providing your employees with the proper paid leave and coming into compliance with this act. So I do definitely appreciate you showing up and encourage, if you have questions, to send those in to us. A recording of this webinar is on our website. From what I just showed you, you'll find a video link of the presentation. Again, here's our email address. If you have questions after this, please send those to that email address. And once more, our website is right there. And with that, I'll say thank you again to Ben, but we are ready to take questions.
Okay, perfect. Thank you for sharing so much relevant and useful information there. That's a lot of content. We appreciate you all getting through that. There are some questions that have come through. Some of these are maybe just going to be reiterating points that you then made later on in your presentation. So just keeping that in mind. And also for the audience today, recognize that there are some questions that Lydia and Jason may not be able to speak to, just given the phase in which this act is currently in. So the first question is, can you comment on how best to handle partial days off?
So I guess, it's really, I guess, depending on what works best for your business. So I guess the question, is it more providing those 2 hours minimum versus like requiring a half day, a whole day? Like, is that?
I think that's where they're coming from, and perhaps was under the impression that there was no 2-hour minimum. So just
Got
speaking that a little bit more.
Yeah, so, under the act, so if you are, providing leave as under the act, then the act does have that 2-hour minimum. So you can't make someone take a whole day if they might just need 1 hour of time. So having those workers be allowed to just take 2 hours if they need, or if they need 4 hours, but kind of leaving it up to employees to decide how much time to leave.
Is there a required or mandatory minimum for PTO usage over the course of the year?
Like for workers to have to take?
Yeah.
I mean, the act says that they should be able to accrue or have and use, their 40 hours. Although we also understand that workers can carry over any accrued time into the next year. So if a worker decides they don't want to take any time off, and they're accrued, they've accrued that time, then they should be able to carry it over into the next year. However, understanding that, an employer would only have to let them use 40 hours in each year. So even if they have 80, an employer can say, I'm only letting you use 40.
Thank you. Next question, how does this apply to new employees who join the team halfway through a year? And I think it goes back to whether or not you're on that front-loaded or accrual basis.
Exactly. So like we said, if you're front loading leave, you're allowed to prorate it. So like if someone starts in July, then you can give them, their, if they're getting 40 hours each year, you can give them like 20 hours if they're full-time. And they can use that through December. And then once January starts, they get all the hours. But accrual, again, it's the same, the 1 hour of paid leave for every 40 hours worked. So if you're accruing, it would be that same method.
Yep. Okay, don't take this one the wrong way.
Uh-oh.
I know. I am curious about how this is monitored and enforced by the state. Clearly, we all want to align with the law, but can you share insight about enforcement?
Oh, so I know that we are a complaint-driven agency. So usually, if we receive a complaint, then we review that complaint and then we'll determine whether an investigation is warranted. So at this point, every complaint, we receive, we'll look at it, we'll, speak with complainants and then determine whether that investigation is warranted. But at the, so if we ever request information, we'll reach out to an employer, and request copies of documents or their policies, their record keeping, and we might talk with them. But other than that, like it's, an employer should be ready at any point, like for us, if we send them a letter saying we need to see these records or we need more information. So that's kind of, again, this is a brand new law, but that's typically how, we're looking at enforcement at this point. We are trying to emphasize compliance though. So, any way that we can help assist an employer, we're going to try to focus on that because we understand it is a new law.
Mm-hmm. Yeah. Are there resources like templates or anything like that for very small nonprofit organizations? Maybe those that have 1 or 2 employees, and then the basis of their work and their mission fulfillment comes from volunteer labor.
So like templates of like policies?
Yeah,
or...
that maybe just don't have that HR infrastructure in place, and very small shops.
So I know that we don't currently like have templates to offer employers. Usually we just recommend speaking with counsel just to develop those policies. Because again, they're, if you're developing a policy from scratch, it might be helpful just to understand the way that this law also works with other laws like the Wage Payment and Collection Act. And then they can also help you develop a policy that works best, because we also understand not every employer is the same and may have different nuances. So, so yeah, we don't have templates of those policies. Our posters, however, are on our website. So, those are kind of the basics of what everyone should know and keep in mind.
Yep. Just a couple of more questions here. One person asking for clarity on the word bona fide. So when you were talking about the pre-existing policy and using that term a couple of times, can you talk a little bit about what you mean?
Yeah, so I know like we have pre-existing qualifying, policy, but I guess with bona fide, we want to ensure that this is thing that has, been around and been in practice. So, because we also understand there might be situations where something is a policy on paper, but not necessarily in practice. So we want to ensure when we say bona fide that this is something that your employees have already like known that this is the policy and it existed before January 1.
Yeah, thanks for that clarification. The last question we have says, can you talk a little bit more about what you mean when you say you can front load PTO, but it can't be diminished later? Maybe another example other than the one about an employee leaving the organization halfway through the year.
So I guess when we say retroactively diminished for front-loaded leave, I think what we mean is employers can't make an employee pay back any of those, benefits. So I think it was if they were to leave employment, or as we also mentioned, if they don't work as many hours as anticipated, right? Like if there's a schedule change and, but the employer front-loaded that leave, like they cannot make that employee pay any of that back. So I think that's what we were trying to say, like an employer can't take any of that front-loaded leave back.
Okay. Yeah, thank you for that. That's our final question. Anything else to add, Lydia or Jason?
I don't think so. I mean, I know I still have our email address for the paid leave questions. Currently we're still in the middle of developing this division. So I would just say, please be patient with us. We have our hotline as well, but it's going to take some time for us to get to your calls or your emails. We're doing the best we can. But, please visit our website, for those frequently asked questions, as well as, sending those questions. Just know that we really can't give that legal advice or let you know if, your policy is necessarily compliant, because we also don't give like advisory opinions, ahead of time. So, if you just need general guidance, we're happy to answer questions, but more specific to your specific facts, we might not be able to provide that answer.
Thank you to Dawn for drawing my attention to some that came in the Q&A. That didn't pop up as a notification for me, so we do have a couple of more. So one person's asking, can an employer set any maximum rollover amount of paid leave hours or days?
Oh,
rollover?
Like carryover, so they can only carry over a certain amount per year?
Can the employer set a maximum rollover amount?
I mean, they're allowed to carry over 40 if they wish. But can they set a maximum, as in you can only, you can't roll over any more than 40?
I think that's the way I'm interpreting Tim's question. He can jump in if he has additional thoughts there, but I'm thinking year over year, then does that continue to stack up? Could they say, you know what, 40 is the maximum that can be carried over? Let's see if he speaks in the chat to that. No.
I mean, because I would just kind of go back to the act and whatever the Act states. And so I believe that because everyone is entitled to accrue 40 and then they can kind of roll over those 40, then that's kind of, you know, what you should be able to accrue. Granted, I know if there are policies where you provide more than leave, again, this act really just covers those 40. So it is possible you could have additional restrictions on any additional leave that you decide to provide. So if you have like separate personal days that are apart from vacation, or if you want paid leave and then vacation and then like there's all sorts of different things. But if it's anything more than these 40 hours that we're kind of looking at as protected, an employer has that flexibility.
Okay. Another person says, if a holiday is already given off, like a federal holiday, can they use the PLAWA to be paid for that day if it falls within the week of work?
So it would have to be the decision of the employee to use their paid leave time for that holiday. So an employer can't say in order for you to get paid holidays, you know, I'm switching, like, for example, if they previously paid for holidays and now they're saying, now this is just going to be paid leave time that you get, like, that's not within compliance of the act, because that choice is taken away from the employee. So I would say no, just providing those holidays would not comply with the act.
Okay. And then the last Q&A question I see, did I hear you say independent contractors would be covered under this act even though they're not employees?
No, so independent contractors are not covered by the act unless they are domestic workers. I know that is the only exemption, and I don't know if anyone here hires domestic workers, which are those like nannies, like house cleaners, home health care aides, for example. But like we mentioned in our presentation, there are specific requirements for employers who hire domestic workers. So again, talk with counsel, review the act for more of those requirements, but they are the only ones who, even if you're an independent contractor, are covered. But otherwise, no, independent contractors are not covered.
Great questions. All right. Thank you so much, Jason and Lydia. This is very helpful. And thank you all for attending today. As mentioned, you're going to receive the recording of this, and you'll also receive the slides as well as an evaluation so that you can give us feedback about this session and share with us maybe future training topics that you'd like to see. We encourage you to visit dcmp.org for upcoming events like Coffee and Conversation on February 21st and our DCMP member networking reception on February 28th. We hope that you and your team can join us for those events, and want to wrap up here almost on time, 1 minute over, but appreciate your flexibility, and we appreciate all who attended. And once more, a big thank you goes to our presenters for sharing their time and expertise with all of us today. Thanks again. Take care.
Thank you.
Bye. Thanks, everyone.